Very warm welcome to all of you present here. On behalf of Enfold Proactive Health Trust, we thank you for joining us for this webinar on due process and the child's best interest, reflections on admissions of guilt under the Juvenile Justice Framework. As we can see, we have a pan-India participation. Before we get started, a few housekeeping rules to ensure that we have a meaningful and engaging discussion together. During the session, we request all participants to keep your microphone on mute and your videos off. After the panel discussion, we will be opening up the forum for discussion, questions, and comments. At this time, you may raise your hand and we will call you to unmute to ask questions. Please feel free to use the chat box to put up questions. Our team will draw the attention of the panelists to the questions in the chat box during the discussion session. Please be respectful and constructive in the chat and during discussions. Lastly, do note that we will be recording the webinar. Enfold runs the Child Rights and Access to Justice Fellowship with a cohort of 24 lawyers from 4 states, Karnataka, Madhya Pradesh, Uttarakhand, and Tamil Nadu. These lawyers represent children in conflict with law at district level JJBs. The concept of plea bargaining was examined by the Law Commission of India in its 142nd, 154th, and 177th reports, eventually leading to its incorporation into the Criminal Procedure Code through the Criminal Law Amendment Act 2005. These deliberations, however, did not specifically address its application to children in conflict with the law, nor did they fully engage with the implications for vulnerable groups within the juvenile justice system. The Juvenile Justice Care and Protection of Children Act 2015 is premised on a child-centric rehabilitative framework guided by principles such as non-waiver of rights, participation, and the best interest of the child. Within this framework, the increasing reliance on admissions of guilt in proceedings before juvenile justice boards raises a number of important questions. In the next 2 hours, our panelists will reflect on the use and implications of admissions of guilt in juvenile justice proceedings, examine existing practices and safeguards, and identify ways to strengthen child-centered, rights-based approaches in line with the JJ Act. Today, we have with us the panelists Geetanjali Goel, Professor Dr. Kumari, and Advocate Maharukh Adenwala. Ms. Geetanjali Goel, District Judge, is currently posted as Officer on Special Duty, Rules and Litigation, High Court of Delhi. She has over 22 years of distinguished experience in the judicial service. After practicing law primarily in the Supreme Court, High Court, and Central Administrative Tribunal, she joined the coveted Delhi Judicial Services in 2003. Over the years, she has presided over diverse jurisdictions, including Civil Courts of Metropolitan Magistrate, Mahila Courts, and the Juvenile Justice Board. She was promoted to the Delhi Higher Judicial Services in 2014. She has also been the Director of National Legal Services Authority and Special Secretary of the Delhi State Legal Services Authority. She has written articles and contributed to the training modules prepared by the National Legal Services Authorities, given lectures on diverse topics regarding women's rights, child welfare law, disability law, and working of the criminal system in the country. She was a member of the committee that drafted the Juvenile Justice Care and Protection of Children Model Rules 2016. We also have Dr. Kumari, who was the Vice Chancellor until recently at National Law University, Odisha. She was Dean Faculty of Law at Delhi University during 2015 to 2018. She is a pioneer in legal research in the area of juvenile justice. She has many books and publications on the subject. Finally, Advocate Maharukh Adenwala is a lawyer practicing in Mumbai. Her practice focuses on children, both child victims of sexual offenses and children in conflict with law. She was appointed as a legal aid lawyer before the Juvenile Justice Board for 3 consecutive years in the early 2000s. Presently, she represents children whose inquiries are likely to be transferred to Children's Court. I now invite Bharti Ali, who will moderate this session. Bharti Ali is a development professional and a social activist working on gender and child rights for over 3 decades. Passionate about child protection and access to justice, she has closely worked with several organizations, networks, and government bodies for the realization of children's human rights. I will now hand over to Bharti. Thank you, Bharti.
Yeah, thank you, Anne. Thank you so much. And warm welcome to everyone once again. So the webinar today is intended to facilitate a reflective and solutions-oriented discussion. The discussion will proceed from conceptual and rights-based questions to judicial and institutional safeguards, followed by practice realities, ethical dilemmas, and finally reforms and the way forward. So, in effect, we are going to critically examine whether admissions of guilt are consistent with the foundational principles of juvenile justice, the structural and institutional factors that may encourage routine reliance on such admissions, the implications for due process participation and rehabilitation, the risks of dilution of safeguards such as legal aid, social investigation reports, individual care plans, follow up support, and finally, the safeguards and reforms necessary to preserve the rehabilitative and child centered character of the juvenile justice law and the system. Now, in this backdrop, our first panelist will be Dr. Kumari, followed by Geetanjali Goel and Mahrukh Aidinwala. Each panelist will have approximately 15 to 20 minutes to share their thoughts. And after the panel discussion concludes, we'll open the discussion for questions and answers. And as Anne has already mentioned, you can type your questions in chat box or raise your hand. We did receive a lot of questions during the registration process and have tried to keep those concerns in mind while designing this webinar. However, if any of those remain unaddressed after all panelists have spoken, we'll take them up first and then move on to questions which are received during the webinar. So, taking on now, I invite Dr. Kumari to throw light on the tension between the child-centered and rehabilitative framework of the Act, particularly the principle of non-waiver of rights and the practice of admission of guilt. Also, the risks for the juvenile justice system arising from increasing reliance on admission of guilt. Over to you, Ved.
Yeah, so I'm saying I'll start with the Constitution. Article 20, Clause 3, very specifically says that no one can be forced to be a witness against oneself. So the principle of protection against self-incrimination. And it applies to everybody. In case of children, it becomes even more important in the light of the basic principles and fundamental principles in Juvenile Justice Act. But to start with, and we need to understand that in how many ways this confession of guilt may come before the JJB. I've seen many magistrates, JJB members, principal magistrates, actually inciting or encouraging the child to tell the truth, because good children do not tell lies. And that has been the approach in SIR's also social investigation report by the social workers. And I've certainly seen this in the preliminary assessment also, where children are put in an environment where they feel compelled to tell the truth, to prove to themselves and to others, I think, that they are good children, they're not bad. And the protection is against coerced confessions. This is not a coercion in the same sense we understand the police coercion, but it is happening while the children are still in custody. So in that sense, when the children are saying, giving a narration of what has happened, which implicates them, that testimony alone cannot be admitted as evidence and cannot be a basis for conviction. In the case of adults, if it's a coerced confession, it cannot be the basis for conviction. In case of children, so one is that how much reliability is there of a child's evidence. So child can be a witness to a crime and or the child can be the offender in the case. So in both cases, the testimony is very much admissible. In case of a child witness, the testimony of a child witness, which is reliable and without coercion, can be the basis of a conviction also in adult court. In case of children, committing an offense and making a confession of their own act, that is inadmissible. One, it is an extrajudicial confession. The second one is also that if it is part, this is usually part of the SIR or the preliminary assessment or the JJB members themselves encouraging the child to tell the truth. In all these cases, the protection which is required to be exercised in case of children is to tell them that whatever you say can be used against you. But what is being done is that, no, we will make the best effort, you will go home, so some kind of lucrative promises are made, or they are encouraged to tell the truth being a good child. So all those kinds of inducement to tell the truth without telling the child that what are the implications of telling the truth in his case, that whatever he says can be used against him and can lead to various kinds of consequences. So all that the judges have very categorically said that conviction of a child on the sole basis of their own confession cannot be held. It is not permissible. One, what they've said to the psychiatrist, for example, becomes part of a hearsay evidence. This is what the child said to the psychiatrist. And hearsay evidence is also not admissible. And it is any confession which is not made in proper format by the judicial officer is not admitted, certainly not before when it is made before the police or it is an execution of body. So the probation officers or the psychiatrists become extrajudicial bodies from before whom the child may have told the truth as he seizes. And I was actually looking at one of the preliminary assessment reports where the child gives a full narration of what all happened and why did he do what he did and what were the prompts, etc. And in that one, of course, he said that we went home and we brought the knives. We gave him blows because he has been bullying us in the past for a long time. And on that day also, he bullied us. So it was a confession by the child, but the report does not mention what are the circumstances, what led the child to tell all this truth. So this was part of the routine filling of our form. And if that report is presented before the JJB, the purpose of this report is to understand his capacity to think, his mental state, etc., as a proof of his will. I think human mind has this tendency that if the child himself is saying that he has committed the offense, then you go towards conviction without assessing constantly that there has to be independent, sufficient evidence to convict him without that statement. But in the mind of the judge, that statement does leave an impression. And I think that's where the lawyers have an important role to mention to the court that this cannot be relied upon and examine what are the other independent evidence there in the case produced by the prosecution on the basis of which conviction can still happen. I think it's very important for children to know that what they're saying is likely to be used. And my sense is that actually the probation officer or the psychiatrist must black out the area where the child gives a narration in the form of a confession. That should be blocked out so that the judges do not get to know, because the conclusion the psychiatrist is making on that confession is that he has a good memory, he can recall the incident, he is systematic, he can think coherently. All the other conclusions with the judges, with the psychiatrist is making, there's tick marking on the basis of that statement. But the judge will be influenced by the admission of guilt as well. So I think it is important for us to ensure that at that point of time when such evidence, such statements from the JJB asks for the full file from the psychiatrist. And the psychiatrist, without any questions, hand that over. While it is completely in violation of the client confidentiality principle. The psychiatrist is in a therapeutic mode, is a therapeutic conversation with the child where the psychiatrist is encouraging the child to face the truth and deal with it. That's a very different context. And that's a very, very different purpose that the child is encouraged to make those statements. But when they are produced before the judge as it is, then it influences the judge's mind also. And I think that's very, very unconstitutional, and it is completely against the rights of the child, not only against the interest of the child, but against the constitutional right of the child also to be not a witness against oneself. So I think it's a very important area where the procedural lapses because of this lead to, and especially in cases where the child is alleged to have committed a heinous offense, it leads to a very, very serious consequence. So when it's a POXO case or it's a murder case, it can lead to very severe consequences for the child. And the child is not aware of the consequences of what he's saying, what all can happen. And therefore, the Supreme Court has been very clear and repeatedly said that conviction on the basis of the child accused own testimony is not admissible. Cannot be the sole for conviction. One has to look for other evidence, independent evidence. The burden to prove the guilt is on the prosecution, and it is not the duty of the defense. It is not the duty of the child to prove the guilt himself. So I think coming from there, we have to look at that the precautions which have to be taken against in case of children under the Juvenile Justice Act are much more. It's not a question. Nobody can waive a constitutional right, and children certainly cannot waive their other statutory rights as well. So it cannot be assumed that when the child confesses to the offense, whether before the JJB or before the probation officer or before the psychiatrist, is waiving his right to a right against self-incrimination. He may not even understand what is the meaning of the right against self-incrimination. And without warning, we encourage the children to tell the truth. And I think that's a major violation of child's rights. Let's start with that, Bharti.
Thank you, Ved. You've raised some very, very critical concerns. And I think a lot of us share those concerns, but because, the practice is only increasing day by day. And that's what now brings me to Geetanjali Goel, because she's been on the other side and she continues to be a judge. So maybe, Geetanjali, if you could share your thoughts around, the fact that some jurisdictions continue to use pleading guilty as a practice, and they also then, get children to pay a fine and close the case. So I invite you to enlighten us on how can we balance the need for speedy disposal, because that is coming out very starkly in these jurisdictions where such practices are used. So how do we balance speedy disposal with meaningful engagement with children's circumstances, rehabilitation needs, and best interests? And how do boards really assess, or should they assess, whether a child's admission of guilt is truly informed, voluntary, consistent with due process and best interest principle? Because Ved has already questioned the constitutionality of such a practice. So over to you, Geetanjali.
Thank you, Bharti. First, I must congratulate you for organizing this webinar and on such an important issue on which I think there has not been much reflection or discussion on it. So it forms a very important part of the juvenile justice system. I'll have some straight thoughts and some points which I would like to raise. At the outside, I would also say it is not really a question of legality or a legal question. It's more of sensitization and how it is being implemented. If we look at what ma'am has talked about just now, so I agree with her that if a child has stated what the incident was or what had happened, and that has been reproduced in the SIR or maybe the report of the psychiatrist or a counseling report or whatever, that cannot be treated as a confession of guilt by the child. In fact, even in context of the police, there are specific judgments from the Honorable High Court and the Supreme Court which say that they cannot be forced to confess his guilt, or even the child cannot be made any statement or any document by the police. So in that context, even if the child is telling about what happened or he's narrating the incident, it cannot be regarded as an admission of guilt, and it cannot form the basis of convicting a child. Okay, we are using the term convicting, though we do say found involved or whatever, but we cannot use that as the basis. I agree on that. And it cannot in fact be regarded as a conviction at all. However, the way in the legal system we understand admission of guilt slightly different. I will just come to that in a couple of minutes. From the note which had been given to us, there was another question which was put for Ved ma'am, which was regarding whether, when admission of guilt is done and courts are like the JJBs are resort to admissions of guilt, do we stand the risk of transforming JJB into resembling conventional courts? So I just wanted to say a couple of points on that. In fact, when we raise this question that whether we are going to transform them into conventional courts, in fact, the opposite is there. I think the admission of guilt is used more in JJPs rather than in the regular courts. This is also for the reason that in criminal courts, regular criminal courts I'm talking about, there are very few cases in which the accused would be pleading guilty. And the reason for that is that, we know whenever an accused pleads guilty, obviously a conviction is attached to it. Unless the accused gets the benefit under the Probation of Offenders Act of a younger age, or he's a first time offender, or for those offenses which are covered therein, there's a stigma attached. So obviously the conviction will be there, and that can have consequences. He can't apply for a government job or whatever. Also, then it could lead to some kind of a sentencing or a punishment. So normally, if you see the regular courts, the cases where the accused would plead guilty would mostly be traffic challans. It could be minor offenses like which we try summarily, or even some like smaller cases, and where the accused does feel that maybe he can be just fined or let off with admonition. But where the accused does feel, or there could be cases where he has already remained in custody for a substantial period, and now he feels that if he guilty, then he'll get off on the sentence that has been on the period that he has been in custody already. So normally we call Delhi mein, that's how they call it. They katti pe chhoot jayenge. Okay, so that is why if you look at the regular courts, in fact, the plea of guilt is not so much in the cases. In fact, one point was initially raised by about plea bargaining also. So as we understand, bargaining is not applicable in the cases of children in India, and that is also with a specific reason, because that requires an application and an affidavit being given by the accused stating that he's a first time offender and he wants to plead guilty. So obviously, we understand in the case of children, can't ask children to be giving affidavits. Okay, so here, if we, on the other hand, if we look at the JJBs, child uh, does admit his involvement in an offense, then we do know that there is a wide decision which is there with the boards to pass any kind of dispositional order. Not necessary that in every case the child has to be sent to the special home or a place of safety. And we have, like, even in when I was there in the JJB, there have been instances which I often refer to, that even in a case of murder, uh, there might be cases where we have left off the child with just admonition, while in a case of theft, we have kept the child in the home perhaps for 1 year, 2 years, or even 3 years. So, which was the maximum. So, in the JJBs, the dispositional order is not dependent on the gravity of the offense. So that is why sometimes, as I will come to it a little later, what we talk about admission of guilt may actually work in the interest of the child. Then obviously, as I said, where we concerned with the JJBs, we also know that the law itself lays down that even if a child is found involved in the offense, then no records are made, no stigma is attached to it. So, irrespective of the fact that the child has been found involved in the offense, or in adult sense, if we use the word convicted, it will have no bearing later on. I mean, that record is not to be maintained by anyone. The police cannot say that where he was involved in an offense, and nobody is going to certify that he was at any point of time involved in the offense. Along with that, now coming to the other points, I would like to say that obviously the question of truth does come in. Are we going to encourage the children to speak the truth, or how we are going to look at it? And the basic principle is of presumption of innocence of the person. Right. Taking it from there, that is also part of the fundamental principles which have been laid down in the JJ Act. The second, then the part which comes is, if we look at the process. Okay, not that I'm advocating that children should be made to admit their involvement, and just taking it forward that in certain cases where it is in the interest of the child, then maybe the child may be allowed to admit his involvement. Look at the JJ Act and the model rules. Uh, the way they have been framed now, so Delhi, we had this practice since earlier, but now that has been brought into the model rules also. The process of rehabilitation does not wait till the child is found involved in the offense or not found involved in the offense. I don't know what the practice is in other states, But at least in Delhi and as per the rules also now, it's mandated that the day the child is produced before the board, the rehabilitation process has to start from that day itself. Okay, there could be two kinds of situations. One is where the child is apprehended, know that the child has to be produced before the board within 24 hours of the board is not sitting, the child would be produced before the individual member. Now, at the very time of the first production, the board has to ensure that the child is represented by a counsel. If the child does not have a counsel of his own, then a legal aid counsel has to be there to represent the child. The board is to interact with the child. The board is also to look at the social background report, which the police is supposed to prepare. Along with the social background report, police has also to give before the board the circumstances which led to the apprehension of the child and other factors which might be there with the police, whatever is available, and thereafter only the board does take a decision whether on the very first date the child is to be released on bail, the child is to be sent to the home, or the child could what called discharged or maybe totally released from the case itself. Okay, there could be instances where the child requires counseling, then the child counseling. If the child requires de-addiction treatment, then also the child would be sent for that. In boards, we need to understand, in JJBs, we do need to understand that these are processes which cannot be prolonged or kept in abeyance till the actual finding of involvement or non-involvement of the child. If a child needs de-addiction treatment, we can't delay sending the child for that kind of treatment, right? So again, on the very first day, the board would also direct the social investigation report to be prepared by the probation officer. If the age documents are not there on record, the board would then direct that the age documents are also produced on the next day. Further, if the child is sent to the home, the law requires that every 15 days the child is to be produced before the board. So that like the board can give shorter dates depending upon its pendency or whatever. But every 15 days the child is to be produced before the board. The board can continuously look at the progress of the child and also see whether the child is undergoing counseling or reports are prepared and all those things. Even in cases where the child is on undertaking, now it doesn't talk about the model rules, don't talk about production within 24 hours, but at the earliest. So the obviously the idea is that for 3 days the child is produced before the board. Again, the board has to undertake all these processes. Now, why I'm talking about this is that this becomes relevant if we look at the way in the legal sense that we look at admission of guilt. So, if by the time the final report, as we call charge sheet, by the time the final report is filed before the board, so already age inquiry would have been completed. The social investigation report would have been there before the board. Then, even if the counseling was required, the child would have gone through several sessions of that. If the child is outside, maybe like some rehabilitation processes had to be started. The child was to go to school or whatever, that would have started. So once the final report comes, then what is required to be done? Then the board is required to supply the copies to the child or maybe his counsel. And the next stage after that, what we call serving of a notice. In regular terminology for other cases before the adult courts, in some cases a notice is served, in some cases a charge is framed against the accused. Now, in cases of the children, irrespective of whether it's a heinous offense, it is a petty offense or whatever, the notice which is served upon the child. Now, what is a notice? Notice is basically a summary of the allegations that have been leveled at the child, which are then explained to the child. And that's why I say it is more of implementation. So, if those allegations are explained to the child by the board that is mandated to do, then the child is asked whether he admits his involvement in those allegations regarding those allegations or not. Obviously, we do know that as we keep emphasizing that the lawyer has to be present on every date, the lawyer has to be there to represent the child. The lawyer would have also informed the child about what is going to happen. Likewise, the parents are also like if the child are there, the parents would be available. Parents would be present in the court when the notice is served upon the child. So legally, if we really look at admission of guilt, it is at that stage when the notice is served upon the child. It is not that any statement made by the child either to the probation officer or the psychiatrist or any other social worker or any other person or police which will really weigh to determine the admission of guilt. In fact, what ma'am was talking about, if that is, if the child has narrated about the incident where he has spoken about his involvement or whatever, that would influence the board. That would in fact be more material when, after going through the evidence, the board passes a judgment on whether the child is involved or not involved. Though obviously the board still has to depend upon the evidence which comes, but otherwise it would have otherwise board has to decide as per the evidence which comes, but there could be a possibility that it does remain at the back of the mind. However, when a child himself or herself is admitting the involvement, then whatever action is taken further is purely as per what the child has stated in a reply to the notice which is served upon the child. So as we look at it legally, so at that stage, if the child says that I was involved in the offense, then only the board has to determine whether to accept the plea of guilt or not to accept it. So this also I must emphasize, it is not mechanically that the child says, "मैं अपनी गलती मानता हूँ, I admit my involvement in the offense." The board will straight away go ahead and record a finding of admission of guilt and find the child involved in the offense and pass the dispositional order. Even in regular adult courts, the court is not bound by the plea which is taken. The court has to further examine it, and even in case of children, it is even more important that the board would examine the plea of the child and then take a call whether the child is to be treated, whether the plea of guilt is to be accepted or not. And here also, as it was said about the safeguards which we obviously it is very important that the board must explain to the child what is contained in the notice, the allegations which are there against him. Also, the board must explain to the child that if the child pleads admits his involvement, what would be the consequences, what kind of dispositional order it could entail if he does admit his involvement in the particular offense. The board also is mandated to ensure that the child is not making that admission under any coercion, under any influence. A lot of times when children are in observation homes, maybe another older child would tell him, "Galti maan lena, please admit your involvement. It will lead to a lesser sentence for you or a lesser punishment for you." The board also has to satisfy itself that the child does uh, know what is happening, and there are various ways in which the board can try to find out. I mean, like again, it is question of asking the child, "Okay, tell us what happened." So there, the board would know whether what the child is telling is really the truth, that he was involved there, he was present at the spot, he was involved in the offense or not. The board could also verify from the lawyer, from the parents. So it is only after looking at all the facts that the board has to take a decision whether to accept the plea of admission of involvement or not, and thereafter the board would proceed. So see, again, as I say, it is a matter of sensitivity, sensitization, how you would deal with a particular situation which comes before you. We can't simply say that if a child is admitting his involvement, it is against the best interest of the child. As I mean, I look at it more from a practical point of view, that there are cases where, like, the child is a first time offender, there is a family which is there to take care of the child, he is regularly going to school, then it doesn't make sense that we put the child through the trauma of coming to the board again and again. We must also remember that the very process, child may have committed a mistake. I'm just starting with that presumption that the child has committed a mistake or has committed an offense. That, but and spot for that, that whole process becomes very traumatic for the child. When a police officer catches the child, asks him all kinds of questions, then he's to be produced before the board. I mean, we can understand that most families, like the parents, would also be angry with the child, would probably shout at him or whatever. Then he has to come to the board. He's not sure what the consequences could be. He could be missing out his school. That whole process can be traumatic for the child as well. So in that circumstance, if by the time the final report comes, the notice is served upon the child, the SIR is already there, the age inquiry has already been done. We don't see any reason, to prolong the matter further. And the child does say that he was involved in the offense. I don't think that we should take a very strict view and say that it is not to be accepted or it amounts to any waiver of rights. Ultimately, that is also a right which the child is exercising by stating that yes, he was involved in the offense and please proceed with the matter. So regards the question of whether this would be consistent with due process or not, this is the requirement of law by itself, that a notice is served, allegations are explained, then the child is given an opportunity to say whether he was involved or not involved in the offense. The question then is of the best interest of the child, which is, as we see, a golden thread which runs through the whole juvenile justice system. So as I've mentioned, that when we do talk about the best interest, we cannot take a narrow view, say that just because the child has admitted his involvement, it will take away his rights, it will affect him adversely, or it could be it will be contrary to a rehabilitation plan. The question is, what is the objective? The whole objective of the juvenile justice system is that we can ensure reintegration of the child, rehabilitation of the child. Even if the child has admitted his involvement in the offense, and based on that the board comes to a finding that the child is involved in the offense, the board is not the responsibility of the board to undertake the rehabilitation process is not over. The board is still required to prepare the individual care plan. In cases where follow-up is required, the board would be undertaking follow-up. The rehabilitation process would still go on as it would go on in the case where, after looking at the entire evidence, the board comes to a finding that the child is involved in an offense. In fact, I may also say that we have had cases where it is found that the child was not involved in the offense. Okay, he was found not guilty. Yet the board decided to send the child to the CWC because they felt that there was no one to take care of the child, or maybe like if the child was sent back to the family, it was not in his best interest. So the board has taken steps even where the child was found not involved in the offense. So if we look at the objective of the entire Juvenile Justice Act and we look at the interest of the child, I'm not saying that in every case that the child could be made to admit his involvement, but in cases where genuinely we feel, or the child genuinely comes forward and says, then we should not also reject that plea which is taken by the child. Then at the same time, I would also agree that compelling that the child should not be compelled to confess his involvement or admit the involvement, and it cannot also be seen as an escape in order to have speedy disposal of matters. In normal course, I mean, like if you look at the whole system, it is not a trial which we have in JJBs, not have an adversarial system. It is essentially an inquiry that we have, and going by those principles, I do not even see why the JJB should be having huge pendencies. So, in those circumstances, using this admission of guilt in order to have a speedy disposal ought not to be resorted to and cannot be resorted to. There are various other ways in which speedy disposal of matters can be achieved. However, I would also say that in cases where the child is admitted to involvement, and genuinely so, if we do accept the plea of guilt, it does free the time of the board and on those cases where the plea of involvement is not there. In all these situations, ultimately what we are looking at is rehabilitation, reintegration of the children, and that has really nothing to do with the involvement, admission of involvement, or not admitting the involvement in the offense. The board has to undertake the rehabilitative step, has to take a follow-up wherever it is necessary. As far as just one. Okay, so basically, what I really want to say is that it cannot be at cost of rehabilitation needs or long-term best interest of the child. There has to be a balancing between speedy disposal, which is actuated by due process, but it should not be hasty also, and it has to take into consideration principles of natural justice. And coming to just a couple of points which were there, informed decision making would, where the board explains the consequences to the child, the lawyer explains the consequences, and only after that the plea of admission of involvement is accepted. That's all, Bharti. Thank you.
Thank you so much, Geetanjali. You're actually right that this is more in practice in JJBs than regular criminal courts, because when we look at the NCRB data on conviction, again, not the term to be used, but it shows 88% conviction rate for children in conflict with law, and a lot of it is a result of admission of guilt. We don't have exact statistics on that, but definitely experience from ground tells us that that's the case. I don't know, whether there is stigma attached. I mean, in statute there is no stigma attached, but in reality, probably children's realities are very different from what we assume. So, the moment a child comes into the system, there is a sort of stigma that sets in. There's labeling that happens. But more importantly, you've also talked about the fact that there is an SIR, there is a rehabilitation process that sets in from day one the child is produced before the board. But as I began on the note that the practice we are seeing on ground is that children are being asked to plead guilty, and then they are asked to pay fine, and the case is closed. So actually, again, the rehabilitation measures don't really roll out in practice. So these are some practical concerns that we have. But what stays with me is also what Ved said, that there has to be sufficient evidence to convict someone without confession. And so there's that on one hand, and there are other practical realities which you've also thrown light on, where you've tried to say that in some cases it appears to be in the best interest of the child to actually allow admission of guilt. And somewhere the lawyers are caught in this trying to balance the practical realities with ethical dilemmas. So thank you so much. I'm sure there are questions that will come your way. I'll now request Maruk to share, based on her experience, how does she navigate through this through this dilemma of realities and ethics and law. And there is already a question in the chat box. Let me read that out also, Maruk, while you try to address us today. The question is, if the child who is facing mental trauma and is getting hallucinations and anxiety episodes because of the act, what he has done, and wants to plead guilty despite knowing what would be consequences of the plea, the decision which his psychiatrist also reveals that he carries the guilt and he requires healing, and accepting the guilt would heal him. What should be the role of an advocate in such circumstances? And the second one is, the child is left out on bail and he is alleged of theft, and the child agrees that he did it. His parents cannot afford to bring him to the observation home every now and then, as they live in a remote village and are daily wage earners. For them, justice is getting the case closed. What should be done in such cases? So between realities and ethics and law, can you throw some light on this and help our lawyers, give them some guidance, Maruk? Thank you.
Thank you. Thank you. Well, I'm going to actually share my personal experience of working with the Juvenile Justice before the Juvenile Justice Board. Can everyone hear me?
Yes, we can.
Okay. So I would say that in most cases, it is not advisable to plead guilty. Pleading guilty is not a routine exercise which lawyers should follow merely because the Juvenile Justice Board is pressurizing us. But as Geeta's also put in the chat, there are situations where pleading guilty is an option in the best interest of the child. And that option cannot be selected by the lawyer alone. I believe it is a psycho-socio-legal decision, which is per the framework of the Juvenile Justice Act. It is not a mere legal decision to shut the case as soon as possible and get the child out on admonition. No. But before I say, so I believe that pleading not guilty is the rule, and pleading guilty is an exception. In certain exceptional situations, not a decision taken by the lawyer alone, along with the child, the parent of the child, the probation officer, the social worker, psychologists involved. There are situations where for the best interest of the child, we may require to plead guilty. But first, I would like to share that there are certain non-negotiables for me, wherein I would never allow a child to plead guilty. One, not plead guilty because the JJB insists that the CCL should do so. Very often, the JJB entices by saying, I'm going to pass an order under Section 18(1), Clause A, you will be released forthwith, or maybe any other non-institutional disposition measure. But no, that is not the reason to plead guilty. The decision has to also be child-centric. Second, I would not plead guilty. The child very often talks to the lawyer. If a child has told me that he did not do it, I would not plead guilty, even if the child wants to. Because I would not feel it ethically correct that a child should plead guilty when he has not engaged in the offense at all. Next, not to plead guilty for the convenience of lawyers. This matter is going on, short dates are being given, I'm giving up my practice in the sessions court or in the high court, and anyway what's going to happen, the child is going to get out on admonition. It's not as if he's going to prison or he's going to be sentenced. No, it cannot be for that reason. Next, I would not plead guilty merely on the basis of what the police report says. Very often it is believed, lawyers say, role of the CCL has so clearly come out in the charge sheet. What chance does he have at inquiry? Of course, he's going to be held guilty. No, that cannot be the reason, because we know that a lawyer's job is to try and acquit the client, do all possible in his or her capacity to get the client acquitted. Another thing, we also know that what is written in the charge sheet and what actually plays out in court or before the JJB are two very different things. A witness may not come or a witness may not support the prosecution case. So what is written in the charge sheet does not affect me at all. It has to be a child-centric decision. Then the biggest challenge is when the CCL is tired of coming regularly to the Juvenile Justice Board. Says, I just want to get out of this rigmarole and I want to continue with my life. I would not even ask him to plead guilty in this situation. As a lawyer, I believe I have to be proactive. I have to ensure that I'm present before the court on every date. I have to ensure that the matter progresses on each date. And there are lots of provisions under the Act and under the rules which enable us as lawyers to ensure that the inquiry concludes as expeditiously as possible. We have to, if the police do not bring a prosecution witness, we have to put it on record in writing. If repeatedly that prosecution witness is not brought, we somehow have to put it in writing that the next witness should be brought and this witness should be dropped. There's no other witness to close the case. The rules also talk about the period within which the charge sheet should be filed in petty and serious offenses. So, we should try and use all these different provisions to ensure that the trial is completed as soon as possible. So these are my non-negotiables when I don't. So somebody would ask, then when do you think pleading guilty is in the best interest of the child? So these are the exceptions. Okay. And some of these, I have pleaded guilty in certain cases before the Juvenile Justice Board under the 2000 Act mainly. So one is, like we talk about best interest of the child and it talks about impacting emotional development. And as the question put in the chat, there have been cases where I believe the emotional development of a child has been impacted because of the ongoing inquiry. And a multidisciplinary team believes that continuing with the inquiry is going to make the child relive the trauma. And this especially happens in the more heinous offenses, in the more serious offenses, where the child relives the trauma constantly. It adversely affects the child's emotional, mental, physical rehabilitation. The child does not want to engage in rehabilitation. All he keeps thinking about is the offense which has been committed. That's why I said, it's in situations where the child has somewhere told you that, yes, I was involved in it. The times when you're worried about causing self-harm. So in those situations, I would plead guilty. And see, we keep talking about a child victim under the POCSO Act being traumatized by being pushed into the criminal justice system. We talk about mandatory reporting. We talk that, it makes the child undergo secondary trauma, but the same is also happens with regards to children in conflict with law. Many of them are not only traumatized by the time spent, they're traumatized by other issues like the offense which has been committed. So that's my first point. My second point is sometimes a CCL does just, them so well, just does not have the mental and emotional wherewithal to undergo an inquiry. Just don't know what he's going to do during the process of the inquiry. I just believe even while undergoing the inquiry, the coping mechanisms of the child has to be really at a particular level. So when I believe that it's just not going to be able to undergo the rigors of an inquiry, then I'm just talking about my, sometimes it's not the period, it's just that he wants to get on with his life. He just wants this sword dangling over his head just to be removed. He just wants to, he may be out on bail, but still it's causing him trauma. Still he just wants to get on with his life. Okay, you have done everything to rehabilitate him. He wants to put that in practice. But this pending inquiry is such a burden on him that he's unable to do so. He feels his life is complete. There's so many children who told me, inquiry ke baad. When we give them options, do this, do that, they're so bogged down by the process which is going on that this question which everybody working with children in conflict with law will know, it's all said, inquiry ke baad, case ke baad, hum ye karenge, hum wo karenge. So they just can't. Then there is another situation, is a child just wants to, I'm just talking about cases where I've used. A child just wants to become a contributing member of society, wants to earn, wants to take care of his family. I've had a boy who just says, he was not out on bail. So he just said, I'm not getting anything in the observation home. And there was a non-governmental organization who had a terrific program which really attracted him. He says, I want to become part of this program as soon as possible. So they're like, after talking with him, after talking with the NGO running that program, we realize he fits into this program very well because it is of his interest, it's for his ability. So in that case, we ensure we were lucky that we were able to select the dispositional measure, and the JJB also understood because all the documents were put before them about this child's capacity and what this program will give him. And they declared that NGO as a fit institution and released him in the care of that NGO, and he really did very, very well. It was an open shelter. There was no, everybody thought, oh God, what if he runs away? No, he was so engaged and so involved in the program. So sometimes, giving them opportunities to pursue their interest as soon as possible. Then sometimes CCL truly wants to repent. He believes he can't live with what he's done. He gets nightmares. He constantly recalls what has happened. He's disturbed, mentally disturbed. He's just unable to engage in any rehabilitation program. So then maybe we do use this option of pleading guilty. And the last thing is when proceeding with the inquiry is a waste of time. Okay, I'll just give you an example. This once when we used it, there was this girl who was trafficked from Bangladesh. Okay, she was trafficked and into prostitution. She registered an FIR with regards to what had happened. This was before the POCSO Act. So an FIR was registered and a trial was going on. Sadly, she was not treated as a CNCP. She was treated as a CCL because of Passport Act, Foreigners Act. So after the trial got over, there was just no purpose in continuing with trial in the adult court with regards to sexual offense got over. There was just no purpose of pulling this. She just wanted to be reunited. Just pleaded guilty and let her go back home. Okay. Now, the role of CCL, okay? So these are the exceptions. But see, the CCL has to make an informed decision. Okay. Like just now we were told that the AJB also tells them about the implications and the consequences which could arise. But we as lawyers also have to explain it to the child. The pros and cons of pleading guilty should also be explained to the child, should also be explained to the family. And alone a lawyer cannot do it. The probation officer, the social worker, all have to get involved in the informed decision. Because we as lawyers will believe that whatever we are saying, the child is able to absorb. No, the child is not. So that's why this informed decision is also a group, a team has to sit and inform, has to answer all the questions which the child asks. A lawyer is also important because the legal consequences the lawyer can answer, but also in regards to others, we need this team who is going to help the child make an informed decision. So your principle of participation happens. Okay. Another thing which a lawyer has to do, has to tell the child that the JJB will pass an order under section 18, subsection 1 and 2. I will argue regarding the suitable order which on your behalf, but I cannot promise that is the order which will be passed. I may argue for a non-institutional order, but I do not ultimately know the order which the JJB will pass. I, as a lawyer, can only make my arguments. It is not in my control. Is the child willing to go into the special home or any other under institutional care? So that is another issue, because a lawyer can only argue. We can argue to the best. And see, even when we argue, it can't be just do admonition and waiver so that he gets out. We will have to use the other dispositional measures, like for a particular child, maybe community service, like I used for a child, fit institution. So we'll have to select the most appropriate, and we'll have to see whether the child agrees to of course, ultimately we argue, but it's completely out of our control. The question which children often ask me is about disqualification. So I like to read to them the provisions of the law and say disqualification will not apply. But as Bharti said, is there a stigma? We can always fight in court, like if he's not admitted to school or he's not given a job or not given a passport, we can always argue this provision. But we also have to tell them that we do not know the police's response. in future, are they going to question you when any offense takes place in that locality? They may just treat you as an offender. So these are the cons also which we need to explain. Okay, then as I earlier said, case against CCL and charge sheet is not relevant. We have to explain that. Sometimes the child says, and I'm like, there's such a horrible case against me in the charge sheet. So no, that cannot, we could tell the child what's written in the charge sheet is not what's going to play out, and that should not be the reason for you pleading guilty. Okay. Also, there have been times when my client, a child, has pleaded not guilty. And during the inquiry before the JJB, he has decided he just can't bear all this. He can't bear listening to what the witnesses are saying. It's affecting him. He wants to just end it. So in the middle, we have changed it to a guilty plea. In fact, there was a time when the JJB refused that you cannot change the plea. We had to go all the way to the High Court to say that the child just is repenting. The child cannot go through, and then the change of plea was allowed. Then, of course, as Goel ma'am said, that it is the final decision is with the JJB. The JJB may decide to reject the plea of guilt and continue with the inquiry. And ultimately, after giving all this information, it is ultimately the decision of the child. It is completely child-centric. It is a decision of the child as to whether that child wants to ultimately plead guilty or not. When listening to the consequences, the child may tell the team, no, I don't want to. Or a child may continue saying, no, I want this to end. Okay. Then sorry if I'm taking up time, but I just want to just say the role of a CCL advocate. It is not a decision taken on the spur of the moment on the day of which the child's plea is being recorded. Whether you believe that a child falls under an exceptional circumstances, it has to be discussed, it has to be assessed, information and informed decision has to be taken by the child. It cannot be that the JJB says guilty, not guilty, and on the spur says, yeah, now plead guilty, on the spur of the moment the child pleads guilty, or you say, okay, he's pleading guilty. No, this is a decision which needs to be taken in advance. It has to be well thought out. It has to be, what are we going to do with regards to the rehabilitation of the child? Does it fall under an exceptional circumstances? Because as I said, it's only in exceptional circumstances will we make a child plead guilty. And as I'm saying, it is a well thought out process. It cannot be decided on the spur of the moment. In fact, it takes weeks to decide what the rehabilitation program should be, what the individual care plan should be for that particular child. Merely because you're pleading guilty, in every case, rehabilitation doesn't have to stop. You know that whenever a JJB passes an order, the individual care plan is attached to that order. And we have to work and see what is the best plan we have for this particular child, because rehabilitation continues. Okay. Then as a lawyer, when it becomes most difficult, the child is trying to forget. When we tell the child, what is he pleading guilty to? That is when the child very often hesitates. Because as I saying, I'm not pleading guilty very often in the petty offenses. Okay. Petty offenses, there are many ways of shutting that inquiry closing that inquiry. So, when the child sometimes they find it very difficult to accept what he's pleading guilty to. So ultimately, but if he still agrees, we'll have to talk with the child about what is he pleading guilty to. Because that is what the child may have to say to her before the JJB. In fact, after discussing the child, I think it's simpler to hand over a written submission to the child after pleading guilty, to hand it over to the Juvenile Justice Board as to what they are pleading guilty, what was their role in the offense. Another thing is, cases where there are two children in conflict with law, I very strongly would not make one of them plead guilty when the other isn't. That should also have been in my non-negotiables. I feel very uncomfortable with that, especially when both of them have had a role to play. Okay, another thing, I don't know, Goel ma'am may have more light to throw on this. Very often when we plead guilty, the Juvenile Justice Board, or especially the adult court, says I have to pass an order immediately. I cannot adjourn the matter. You have pleaded guilty and I have to pass the order immediately. With regards to a child in conflict with law, we could always argue that we have to sit together, think of the disposition measures. So I just tell my clients, before they sign on the guilty plea, we inform the Juvenile Justice Board we are going to plead guilty. Juvenile Justice Board may feel that we need another probation officer's report before we decide the order to be passed. We need a more detailed individual care plan, or sometimes the social work member may not be present. So they give them chance to defer the matter so that all this is understood before recording the plea. Okay, and we also as lawyers have to be ready with our arguments as to what is the best disposition measure, and we have to have supporting documents with us. Like, for example, as I said, if I'm going to send the child to a non-governmental organization and talk about a fit institution, then I should have the program which the child is going to undergo, how it matches with the child's interests. So all that is extremely important. Okay, if child later wants to plead guilty, then of course we have to make a application for change of plea, and even in that we have to be very clear as to why the child is today pleading guilty. Okay, and also we have to be very clear that the choice taken by the child is a voluntary choice. That's why I'm saying you can't take this decision on the spur of the moment, please. Lots of time has to be spent with the child, with the family and other members involved in the child's rehabilitation before this decision before the decision is taken. Now, today under the 2015 Act, children may be transferred into the children's court. Okay, of course. Then, despite the trauma to the child, sadly, we are forced to forced to proceed with the trial because the consequences could be so harsh. So, what upsets me really is that it's in the minor cases where the child is actually able to, and it's not going to take so long, where children are being forced to plead guilty. But I'll also go to tell you one more thing. But even in the adult system, we cannot foreclose. If the Children's Court has passed an order under Section 19, subsection 1, Clause 2, to treat the child as if they were a JJB, then again, sometimes we would have to again weigh the best interest of the child and pleading guilty, because there are certain children who just are too traumatized. And what keeps upsetting me is that we keep talking about a child victim being traumatized, but a child in conflict with law is as traumatized and is as affected. So, sorry, these were just my sharings. Sorry, Bharti, I know I've gone over time. But in lawyers here, I would just like to tell them to brainstorm with themselves and answer two questions, One is they have to think as to because the main reason for pleading guilty is matters are prolonged. So as a lawyer, what can we do to ensure speedy disposal of the cases? And for each lawyer to brainstorm as which situation do you believe falls under the exceptional circumstances where you would consider the child to plead guilty. Thank you. Sorry if I've gone over time.
Thank you so much, Maruk, for sharing your experiences and actually opening our minds to a lot of realities. And as you said, it has to be an exception, not the rule. I'm sure there are many questions that people have. Um, uh, there was one question that we had received while the registration process was going on. And the question was, would you agree with the proposition that guilty pleas by children should be abolished? If yes, why? If no, why? But I think we've reached a position where we are saying that maybe in some cases it is in the interest of the child. And in that situation, what should be the standards that we want to propose? You've already laid the foundation, Maruk, in terms of setting some guidelines around, what are non-negotiables. But maybe Ved and Geetanjali, if you want to come in on that before we open the house for questions.
I do have some observations. I'm hearing a lot more welfare approach than the rights approach in this conversation. And pleading guilty should not be, Maruk has emphasized lots of them, that these cannot be the reasons, the non-negotiables. For me, pleading guilty is one thing and conviction on the basis of pleading guilty is another. Pleading guilty should not mean that tomorrow there will be a conviction and the matter will be over. If that is the reason, because the child cannot take the inquiry, so then there is something wrong with the inquiry, because inquiry is supposed to be child-friendly. If things are not happening right at the other level, and we take the resort to pleading guilty as a way to resolve that problem, then I think it's completely going off the point. Because I don't think the rights are negotiable. And we are also all saying, if it is in the best interest of the child, who decides that best interest? So we as adults, we are determining. We as the court, we as the lawyer, we are determining. And this whole thing about the ability of the child to know the consequences of the pleading guilty. In Bholu, the Supreme Court has very categorically said that the range of consequences that happen cannot be within the grasp of this child. Especially, it is very, very problematic in heinous offenses for 16 to 18 years, certainly, that the consequences are so severe. And therefore, we need to address the delay which is happening, that how to shorten the delay. At what point of time you have to say, no more waiting for a witness to appear. What are the reasons for the case to getting prolonged? So we need to address those points a lot more rather than finding solution in pleading guilty. Because pleading guilty certainly means that you are waiving your basic constitutional right. Forget about any best interest of the child principle. And what is in the best, why when there's all this example that the child is not able to go through the rigmarole. So it is not because he wants to plead guilty, but it is because he can't take the delay in the disposal of the case. So we need to address that, which is causing the child to become desperate. And rather than saying that, okay, because you're desperate, therefore plead guilty and get out of the system. So it's also saying that, no, this is the mechanism for speedy disposal, which we're objecting to. The conviction on the basis, on the primary or the sole basis of pleading guilty is something which is not acceptable. And if pleading guilty today means I'll get my disposal order tomorrow, then it certainly is very, very questionable. It's completely against the Constitution. It's completely against the interests of the child. And any number of High Court judgments I can see where the JJBs have been acting, is functioning mechanically. So I think, having an ideal JJB magistrate like Geetanjali, having an ideal advocate like Maruk is not something which is available to most of the children in the system. We do not have such sensitive JJB members. We do not have such sensitive and believing in children lawyers. So somewhere the realities, as I see it from the High Court judgments, I do not have the ground experience, but when I read the judgments of the High Court, that how mechanically the JJB has disposed of the matter and what all was not pleaded, then I certainly feel that ideally, certainly the lawyers should do this and JJB members should do this and all that. That should really is there. But the moment we come to that I will decide what is in the best interest of the child, compromising the right of the child not to plead guilty or not to be convicted on the basis of pleading guilty. Because my problem is not with pleading guilty. My problem is with the conviction on the basis of pleading guilty. If there is independent document other than this, then let the child plead guilty and let there be other evidence also. But it cannot be that because the child has pleaded guilty, therefore we will order whatever order we need to make. So I certainly think that compromising on the right of the child itself should not be the criteria for, no, this is not a interest versus right balance. The right has to be respected. We are in so many years ago, 1961, when the Inri Goel case came, the court did observe that the child gets neither of the two, neither the safeguards of the adult system nor the care of the child system. And in the name of the welfare of the child, we keep on taking away the rights. So I certainly think that pleading guilty has to be separated from conviction on the basis of pleading guilty alone.
Yeah, we definitely hear you, Ved, on that. And I think the aspect that Maruk highlighted about assessment by a multidisciplinary team, I think that becomes very, very important. As you said, it's the conviction which is solely dependent on plead guilty that that is actually unconstitutional. Yes, Geetanjali.
Yeah, I just want to again emphasize that obviously pleading guilty cannot be the mechanism for speedy disposal. It is only in those cases where, I mean, like where the child is willing to plead guilty, and as Maruk had said, everybody has brainstormed, has thought about it, and thereafter the child wants to plead guilty. I mean, we should not even, I think that's also a right of the child to plead guilty. If the child doesn't want to be put through an inquiry and he genuinely wants to plead guilty, we cannot even take away that right of the child to plead guilty. As far as what Ved ma'am has said about conviction based on plea of guilt, again, as I said, it's for the board to take a call on that. If the board feels that the plea is genuine and it is an informed decision taken by the child, then obviously the board can come to a finding of plea of guilt. Otherwise, the board can also reject the plea which has been taken by the child. I just refer to one thing which Maruk ma'am had talked about. As far as we understand it, if a child has pleaded guilty, the order by the board regarding finding whether the child is involved in the offense or not will have to be done immediately. But it is not necessary to pass the dispositional order instantly. For that, the board can give another date, maybe after 2 days, 3 days, or whatever. And if the lawyers do want to argue on what kind of dispositional order should be there, that can be delayed. So the finding on whether they are accepting the plea of guilt or not accepting the plea of guilt would have to be made the same day. The last point which I really want to make is that, see, from what I'm getting is also that sometimes a child may not want him to plead guilty, or if he's pleading guilty, and then it leads to serious consequences by way of a dispositional order. I think there again, what is needed is maybe for the lawyers to argue more vehemently on the kind of dispositional order that should be passed. And also, I think the JJBs need to be sensitized on the kind of dispositional order they should pass. Merely because the law allows that you can send a child to a special home or a place of safety for 3 years does not mean that the child should be sent there. It is not, as we keep saying, whether it's for bail or whether it's for the dispositional order, it is not the gravity of the offense which matters. It is really the circumstances of the child and whether it is in the interest of the child to be sent to a home or whether we have other mechanisms. I mean, that is the beauty of the JJ Act, that it gives the principal magistrate or the board, I may say, so many discretionary powers to frame the relief as is needed in a particular case. I mean, Section 18 talks about various dispositional orders, but there is nothing that precludes the board from passing any order which would be in the interest of the child. So I think it is the dispositional order which should be viewed more sensitively, and the JJB should also be sensitized on that. That merely because the child is admitting his involvement, irrespective of it's a serious offense, heinous offense, it does not mean that the child has to be necessarily incarcerated. So that is something which we really need to concentrate on also. Thank you.
Yes, thank you so much. Okay, we can take we can open the house for, yes, Maruk, you want to come in?
I want to come in.
Okay, all right, but we'll have to open the house for questions after this.
Yeah, no, because for me, this whole question of the other orders being available in all my trainings, 100%. The disposition chosen in exercises is that if it's a serious offense, send them to home. If it's a petty offense, lead them into admonition. I have not found this sensitivity among my trainee JJB members to say that no, we will look at other factors to determine. And the fact that you're saying that the day the child pleads guilty, order has to be written, which means that it will be on the basis of the guilt only. It is not of pleading guilty only. It is not based on any other evidence which the judge will be looking at, which is prohibited, and which is where the problem is basically, that you cannot base your conviction order on the basis of the pleading guilty alone. And if you have to make an order on that very day, then it is exclusively based on the pleading guilty, which is unconstitutional, which is against the Supreme Court rulings. So this whole compromise, the balancing that no, the child himself is pleading guilty and therefore we record it. You can record it, but that does not mean that you have to pass a conviction order. And especially in cases where the child did not plead guilty in the beginning and now because of the rigmarole he's got himself into, he's want to plead guilty. That's even more problematic. So the prosecution has to prove. And also this whole question of starting rehabilitation from day one. From where does it come? From the presumption of guilt. The child may have been picked up unnecessarily, may have been picked up wrongly, but we have to put now him in a rehabilitation because the police has picked him up. There's a presumption of guilt already at that point of time when you start talking rehabilitation of children in the system. We believe that all the children which have been brought in the system has been brought rightly in the system. They all have parents, they all have schools. My understanding of the kind of family they come from, a lot of children have families, though they don't want to support the child. They're just sick of the child. They don't want to participate in anything. They want to just get rid of the child. So majority of the children, in my understanding from whatever literature I've seen, is not that these children are very well protected and supported by their families in their rehabilitation. So when the judge start talking about rehabilitation from day one, rehabilitation for what purpose? The child might have been properly, no, is one of the regular children on the streets going to school and then roaming around on the road, but it gets picked up and then the police, and especially, Geetanjali, you are very well aware that it does happen that if once found guilty, the police will, first of all, they will pick those children up. And there are any number of cases where they applied for jobs and the jobs, the law does not say that you can say, I have never been convicted for an offense. The law only says no stigma will apply. So if he fills up a form and there is a column which says, have you ever been convicted for an offense? He says no, because he was found to have committed the offense by the JJB, which is not a conviction. But the police report says, no, he has been found guilty by the JJB. They will not give him the job. Then they go to the High Court and the High Court then says, no, this should not have happened. But the law is not very clear that you can, when you say that, no, you have not been convicted, when you have been convicted by a JJB, the law doesn't say so. So therefore, if you don't reveal that he was hiding, if you mention that I have been found to have committed the offense by the JJB, the police and whatever is the agency employing, they do not give them their job. And especially now with the heinous offenses, the records may be maintained. So it's not that in all cases the records are not to be maintained. In case of heinous offenses, the records have to be maintained. So there are a lot of implications of pleading guilty and conviction on the basis of that. And I do not know how many JJB members have the time to explain to the child the full implication of the consequences. And in case if the child goes to the children's court and is tried as an adult, the minimum has to be in the special home. And I've seen, these POCSO courts, which are completely at sea to know what order to be passed. It's a POXO case, but it has come through the JJP. The JJA Act to have to apply. They are passing mandatory minimum sentence in those cases. So the consequences, and during the pendency itself, the child has crossed the age of 21. So not a day of supportive services are provided by the state, and he straight away ends up in jail. So the system today is so very unfriendly to the children, and then to convict on the basis of they pleading guilty. I think it's completely wrong, both in terms of Constitution as well as in terms of Juvenile Justice Act.
Yeah, we are already receiving questions.
Just one small thing I want to say. Just one small thing. So, see, I just want to clarify one thing. When I said that the rehabilitation starts from day one, I did not mean that it is based on a presumption that the child is guilty or whatever. It is basically that if the child is brought before the board is not the board has the responsibility to ensure that if like the child is not going to school, then maybe pass some orders. If the child is if the board it comes to the knowledge of the board that the child is maybe taking drugs or something, to pass an order that the child is sent for treatment and all. I'm not talking about that the rehabilitation is based on any presumption of guilt of the child. It is essentially if the board feels that some orders need to be passed for the welfare of the child. In that context that I refer to that. That's
I was wondering on day one, when the child is produced for the first time, what all information do you have about the child, apart from that he was involved as per the police statement in a crime? What other statements do you have within 24 hours of his arrest?
So we have the social background report, which is prepared by the police. The board itself interacts with the child. If family members are available, we would interact with the child. So you talk to the child. So a lot of things you get to know. I mean, see, I was there for more than 3 years. And initially, obviously, we did not know. But by the time it was like within 3 months, 4 months, at least we were able to get some information out and take call on what is to be done. You learn a lot of things through training programs, through sensitization programs, and also through your experience if you're sitting there.
All right. Yeah. Please allow me to open the house for questions, because people are already, writing things in the chat. So one question is, what about the principle of fresh start, especially of children who have been considered to have committed the offense? And the other question is, if a CICL wants to plead guilty in anticipation of future marriage after he turns 18 in a Romeo-Juliet case, how should a lawyer advise him? So Ved, on the principle of fresh start, would you want to again reiterate your points?
Yeah, I will say the same things, that the moment there is a conviction, finding of guilt, he becomes a suspect in all cases. And the police doesn't, there's so many agencies involved, and to assume that all of them will be sensitive of the principles, even the people who are within the system are not honoring the principles. They themselves also believe in welfare in terms of, finding a balance and ensure that what is in the best interest of the child. How can pleading guilty be ever in the best interest of the child? Maru did give us some examples, but that is happening because the system is not functioning. It's not because of the child's own desire. Even if this is the child's own desire to confess.
I'm sorry, I just want to intervene in that time. Please, all the examples I gave were not because the system was not working. All the examples which I tried to give were child-centric. I may have been misunderstood. When I said the rigmarole of the system, I'm just saying I didn't mean the rigmarole. I mean that a particular child is just cannot handle it. It's because of the child's trait. It's because of that particular child's characteristics. Otherwise, the rigmarole, maybe I used the wrong word, every child would not be able to handle. But there is this particular child which I am talking about. So I just don't want it to believe that I'm saying that every child who can't handle the system should be allowed to plead guilty. Sorry, Bharti, I just wanted to clarify that. I want to say that whatever example I gave were vis-a-vis the characteristics of a particular child and how that inquiry is impacting on that particular child. That's why I said the assessment is extremely, extremely important. Sorry for this. Sorry.
No, Maru, I'm just saying that pleading guilty is one thing. The child needs to confess, he wants to start afresh, he wants to close the matter, that's perfectly fine. But solely on the basis of his confession, the conviction is not acceptable.
Yeah, very clearly, I think what is coming out is that plead guilty is um, unconstitutional if the conviction is solely based on it. It is unconstitutional even otherwise, is what Ved is trying to say. But there may be situations where, in the interest of the child, as Maruf is saying, and as Geetanjali is also trying to point out, uh, it may be a way out, but on the condition that certain processes are followed, on the condition that there is an assessment, on the condition that the child is making an informed decision, and the informed decision, as Maruf pointed out, is not something which one person tells a child, but there is a team that works towards helping the child make that decision. So a lot of uh, let me put it as some kind of protocols have also uh, been set out, or norms or standards or practices have been set out. While we understand that plead guilty is not the way to go for children in conflict with law. Any other questions? And if you have questions specific to a speaker, then please point that out. There's a message. Message from Bipasha Roy, which says, do destruction of records are actually undertaken by the police when JJB and the Children's Court pass the order to that effect? Do they give a report to that effect to the JJB and Children's Court after destroying them? Probably a question to Geetanjali.
Could you just repeat the question, please?
It says, is destruction of records actually undertaken by the police when the JJB and the Children's Court pass such orders? And do they give a report to that effect to the JJB and Children's Court after destroying the records?
See, technically, the requirement of law is that no record is to be maintained. So even if the JJB or the Children's Court does not pass any order for destruction of records, the records are supposed to be destroyed by the police, because that is what the requirement of law is. But if obviously they do give such directions that the records are to be destroyed, then the boards or the Children's Court can always call for a report from the police also. In Delhi, Bharti would remember that we had prepared specific rules even for destruction of records with the boards and all that. So I think the records are destroyed. And I mean, I remember when I had started in JJB, we used to get a stray application here or there where the child would come back to us after maybe so many years of the inquiry being over, that like he had applied for a job, but then the police had written that he had earlier been convicted or was there. But towards the end of my 3-year tenure there, and later on also, now I that is hardly there's any application where the records are maintained, or a child has to come back before the board stating that the records were maintained and the certified that he was involved in an offense as a child. So I don't think, at least like in Delhi and all, we don't get any such instances now. Bharti, you're mute.
Sorry. Thank you. Any further questions? I think we've had a very good discussion. The idea was to make this reflective. I don't know whether we have answers to everything under the sun, but at least we should have our premises correct. We should have our principles in order before we say that we want to work for WAID's children in conflict with law and in the juvenile justice system. So the idea is to just brainstorm and open our minds to various perspectives. Pranay is saying, I have seen in High Court that when a case diary is called in a bail matter, the police bring 10-year-old records of an adult when he was a child. So, little that we can do about police practices through this webinar, but yeah, these are also realities. But we have a pressing question coming up again. I think this is the second time someone has sent this question. Snigdha, what about pleading guilty in Romeo-Juliet cases?
Not at all.
Yes, Maruk, please
I,
go ahead.
as I,
No, but the
I
whole
believe.
question in Romeo and Juliet cases is also that who is the accused person in that case for him or her to plead guilty. We says Romeo and Juliet, then it's consensual and neither both of them are offenders or both of them are victims. If we do not get clarity on that one, and then to ask the boy to say, yes, I did to plead guilty. And Romeo and Juliet cases will always go to the moment he says guilty, I plead guilty, the matter goes to the children's court, and children's court, what my feeling has been that they constantly are passing the mandatory minimum sentence prescribed for the offense, irrespective of the fact that they have to pass the order under Section 19. They don't pass under Section 19. So then the child ends up in jail at the end of it. There's no question of pleading guilty in Romeo and Juliet cases.
I believe the only option there is going for quashing to the High Court, not pleading guilty, because, and I don't think it's really right to plead guilty in these cases, because as I said, it's not the charge sheet of the offense which decides whether you should plead guilty or not. It is vis-a-vis a particular child. How the inquiry is impacting a particular child is what is the issue. And by particular child, I just don't mean the time spent before the Juvenile Justice Board. What I mean is actually the definition of best interest is affecting the child's physical, mental, emotional development. The child does not want to engage in any rehabilitative program because all the child is thinking about is the offense that was committed and having nightmares, getting really impacted. So I'm just saying it is in the context of the child. For me, okay, each lawyer can have their own, or each person can, as I say, lay down their circumstances. But for me, it is the impact upon the child which is more important and is the prime reason, and not the offense which was committed.
I agree totally with what Maruk ma'am has said. In fact, that is my thought also, and what I have been reiterating. We can't simply say that if a child pleads guilty and is thereafter convicted based on that, it's unconstitutional. Because even the law, if you look at any of the sections, they also say, and that is why I specifically refer to the stage where we talk about the plea of guilt, which is after the final report has been filed, the documents have been supplied, a notice is served upon the child. If at that stage the child is pleading guilty, and there again, as I said, it's for the board to accept or reject the plea. Now, the board will obviously accept the plea only if they have considered the other documents which are on record and they agree with it. Otherwise, they are well within their rights to reject it also. All the safeguards have been met, and it is considered that in a particular case, as Maruk has been saying, that it is about the particular child, if it is the child, we cannot say that conviction based on plea of guilt would be unconstitutional. The safeguards have to be followed, no doubt about it. And as everybody has said, it has to be constitutional. But we cannot say that we should do away with the point of or the right of the child to plead guilty in a given case.
Right. So, since this webinar is organized in a certain backdrop, and we do have some lawyers who are part of a fellowship program now representing children in conflict with law in different states. I think many of them have been, disturbed by certain situations where children have been asked to plead guilty. The message that we give to them is what Ved has been saying, that it is unconstitutional, but the realities sometimes are such where people have had to mortgage their land to keep coming to the JJB for the inquiry. But we understand when Ved says that the process itself, the JJ process itself, should not be that cumbersome, that one has to rely on measures which are otherwise unconstitutional because the system is not being able to deliver. But at the same time, those realities continue, and they can't be ignored outrightly. So there is one more question which has come up. I don't think we can respond to your other questions, Snigdha. You may want to take it up privately with Maruk, and we'll try and connect you if Maruk agrees. So the other question is periodic independent evaluations envisaged under Section 55 of JJ Act and Rule 42 JJ Model Rules 2016. Any statistics available with regard to cases of admission of guilt? Not that I have come across. Another one is there was a discussion on rehabilitation of the child in conflict with law. I was wondering if I could ask for the panelists' thoughts on the CCL being categorized as CNCP for that purpose. And the last one is, again from Snigdha, better way to say would be child has to maintain a stand denying sexual relationship instead of calling it lying. I'm not taking the last one because that I think we can have, Snigdha can have a private conversation with Maruk. But the other two, one is about whether we have statistics, and the other one about rehabilitation of CCL and child being treated as CNCP. If any of you would like to respond to that.
So I would just say that obviously, see, there are certain cases where there is no family to support the child or there is nobody to take care of the child. In those cases, the child could be treated as a CNCP and be directed to be produced before the child welfare. The 2015 Act, in fact, allows that even at the initial stage also, when the child comes before the board can treat the child as a CNCP and direct him to be produced before the Child Welfare Committee. And otherwise, if the family is available, then there can be follow-up rehabilitation within the framework of the JJ system, even when the child is with the family. Because ultimately, I mean, in most cases, we do look upon family responsibility and reintegrating the child with the family, except for those cases where we consider that the family is responsible for the child, like getting into offenses or whatever. Rehabilitation can have many facets. It's not necessary that in every case we have to declare the child as a CNC and then only undertake rehabilitation. It can be even within the system of the JJPs that rehabilitation processes can be undertaken.
So, Geetanjali, what would be your advice to juvenile justice boards on the topic that we've discussed today?
See, again, see, I'm sorry, but like I'm repeating that, we cannot, I said that earlier also, we cannot call a plea of guilt and basing a conviction on that as unconstitutional. See, if you look at, though we do say that, the principles of CRPC and all do not apply strictly, but if you do look at CRPC or now the BNSS which we have, there are specific provisions regarding charge and notice. In JJBs, we know we don't make a charge, we call it a notice which is served upon the child, wherein the allegations are explained to the child. That is why I detail that also so that we understand what we are talking about. If at that stage the child is pleading guilty, so even the law has BNSS, CRPC, they have specific sections that conviction can be based on the plea of guilt. But since we are talking about children here, there also, even in cases of adults, the discretion is given to the court to accept it or not. And in the cases of children, what I'm saying is that you cannot call it unconstitutional, but you have to build in safeguards. As Maruk said, certain cases only where which would qualify, where it is in the interest of the child that the child pleads guilty. And those cases only, like those exceptional cases, if a child does want to plead guilty for whatever reasons, I mean, it has to be informed decision. The child has to be informed about the consequences. And again, as Maruk very rightly said, it is not just the boards which have to explain. It is the lawyers who have to explain to the child what he's getting into, what can be the consequences. The board has to explain to the child also. And thereafter, if the plea of guilt is taken, we cannot simply label it as unconstitutional. We also have to respect the decision that is taken after giving an informed choice to the child. So it would not be right to call it unconstitutional, but yes, I agree with everyone, and I would also say there have to be safeguards. It has to be exceptional. It can't be in every case. And again, even where it has been where the child has pleaded guilty, it is further the duty of the board to then examine the plea of guilt and see whether they're going to accept it or they're going to reject the.
All right. So it's the situation that we have with the preliminary assessment and judicial waiver. uh, I'm not sure how to conclude this, but the thoughts are before everyone, and it is for us now to decide what way to take forward. We'll close. We are also, the time for the webinar. So we'll close the discussion here and over to Anne to take this one. The messages will keep coming, I think. Yeah, let's close this. Anne, over to you.
Thank you, Bharti. So we want to thank all our panelists for sharing their experiences on the topic and the participants for asking questions from the ground, especially our fellows of the Access to Justice Fellowship who have been talking about um, their experiences while they started working at the JJB and for children in conflict with law. And it was a very enriching discussion. Thank you very much. Thank you, everyone, for joining.
Thank you.